Hello, this is Matt on the Moon Lambo channel. I really appreciate all of the attorneys within our XRP community who take the time to explain what's been going on and have been for years in the SEC v. Ripple case and now with the appeals process, because the legal nature of what has been going on is so ridiculously complex that regular people like you and like me and most of you listening, we wouldn't be able to make heads or tails of this thing. So I'm very thankful here. But let me tell you a couple things at the outset and set the table for what's going to be discussed in this video. First of all, the people who said that the SEC did need to file Form C for the appeals process regarding the appeal of the Judge Torres decision in the SEC v. Ripple case, the people who said that the SEC needed to file by October 16th were correct. The people who said that, no, you're misunderstanding it, is actually the case the SEC has to file Form C to appeal this thing by October 18th. Those people were incorrect, just to set the record straight, and I actually have some proof, which is on your screen, which I'll be talking about in this video. And also, and I think this is actually perhaps is even more interesting, this actually, and this is speculation, but I think it's pretty solid. It's pointed out that because of this, it seems like it's about a 100% chance that the SEC's filing a Form C to appeal, it's about a 100% chance that it was accepted by the court. And this is just like a hair shy of technically knowing 100% for sure, but seems to be fairly close to that. Then there's this question of what is going on. So you may have heard, and I haven't talked about it on my channel, not the most recent part of the story anyway, but Ripple co-founder Chris Larsen donated XRP to support the Kamala Harris campaign. And there's a question of, wait a minute, if that's sold to support the campaign, is that actually going against what the SEC says is legal? And I have two attorneys within the XRP community sharing ideas exactly on that topic. So it's all interesting stuff. But before going further, I do want to be clear, I do not have a financial background of any kind. I am not offering financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so let me share with you this most recent legal filing here. It came down on the 22nd here, and this was shared by XRP community member Sherry, and it reads as follows. Acknowledgement and notice of appearance default notice. And so I'll note that this also is coming, it's from the United States Court of Appeals for the Second Circuit. Reads as follows. Pursuant to Second Circuit Local Rule 12.3, the Appellee's Counsel acknowledgement and notice of appearance was due on October 18th, 2024. The court has not received the acknowledgement and notice of appearance on behalf of Appellee's Counsel. If Appellee's Counsel does not file an acknowledgement and notice of appearance within 14 days of the date of this notice, when the appeal is placed on the calendar, Appellee's Counsel will not be heard at oral argument except by permission of the court. Okay, and so it's kind of like a warning, hey, haven't gotten a filing, but, and so kind of like getting gear here if we're going to do something, but to who? For what? Well, as it turns out, this is for Chris Larsen. So you can see right here, this is also shared by XRP community member Sherry. Here's the description. Notice to appellee Christian A. Larsen for failure to file an appearance. And so that the date filed for that was October 22nd, but again, the date referenced in here as the deadline was October 18th. And so Sherry is noting here that this is proof that Form C, which again is the form that was required for the SEC to actually continue with the appeal of Judge Torres' decision in the SEC v. Ripple case, that's proof that it couldn't have been due on the 18th, because it would never be the case that there would be a due date for Form C so that the SEC can appeal, and then on the very same day, before we even know for sure if the SEC would even file that, it would not then be the case that there has to be a response from Chris Larsen. Like, of course not. So logic would dictate, of course it could not be. And so that's why when she's highlighting, she's like, this is proof. The October 16th indeed was the date. And there's some, here, actually, I'll read this one too. Somebody was asking, can you explain, does the SEC now say that the filing was due on the 18th? And that's not what's going on. Sherry says it's only proof that the SEC's due date to file their Form C was never due on the 18th. It was always due on the 16th. What is due on the 18th was what you just read above. And so that's what I just read to you. Now, perhaps even more interesting, as I was mentioning briefly at the outset of the video, is the following here. So somebody named Big Bang had a question for Sherry and wrote, does this mean the SEC appeal was accepted? And so that's the thing that we've been wondering, right? Because there's been a question as to whether or not the SEC actually filed late. And in theory, in theory, the whole appeal could be thrown out by the court if filed late. And so it's irresponsible for them to, even if they did file on time on the last day, like that's kind of, if there's not a really good reason, it's kind of irresponsible. But we keep seeing this pattern of behavior that the SEC consistently files at the last moment. They just do that. I don't know if they think that they're being cool. I don't know what the hell it is, but that's just the behavior that we keep seeing from them. So we didn't see, and that, mind you, we're in the age of information. If something is submitted, like if somebody sends you an email, you get that in real time, right? Somebody posts a tweet on X, you get that right away. So it's the age of information. So when something's submitted and there's this expectation that because the way it's set up, it's available immediately. Then when a deadline passes, you wouldn't typically think, oh wow, well maybe they did file it on time, but it's got to be delivered electronically via horse and buggy, so maybe it will arrive the next day or 2 days later. Who knows, right? That's not how electronic information works. It's effectively in real time. So the fact that on October 16th the deadline came and passed, we're sitting there wondering, okay, why don't we see the document? Where's this Form C? Where is this damn thing? And so one of the possibilities is that the SEC just didn't file, or they filed late because they forgot they made an actual mistake, or there's a technical hiccup. So there's like a few things that could have happened, right? And we did see that the next day it was filed with a completely separate date. So we're sitting here left as a community, scratching our heads like, wait, what's going on? Because it's weird no matter what. Like, if they filed on time and then the real-time system was no longer functioning on real-time at a time that just happened to be really crucial and at a point in time where the entire XRP community would be paying attention, if it just failed for that moment and was no longer real-time or there was a delay, a technical glitch, that's weird. That's a weird time for that to just happen to occur. It would also have been weird if the SEC just forgot to file the appeal in one of the biggest cases having to do with crypto, arguably the biggest case having to do with crypto for the SEC ever. And they just forgot to file. Like, no matter what the real answer is, it's weird. No matter what it is. And so it looks like at this point they actually probably did, because again, the question here from Big Bang is, does this mean the SEC appeal was accepted? Well, Sherry wrote the following. Seems so. Otherwise, I'd have expected some kind of notice before this one. So procedurally, why would we be talking about this? Why would they be filing this if there is no appeal at all anyway? So presumably, this would be our first piece of evidence that the court is going to allow the SEC to proceed whether they filed on time or not. And we still don't have a ton of firm answers. I think it's in the public's best interest to just be aware of this, because we already have no confidence in this freaking government agency. So it would be nice to have some additional transparency. But yeah, it looks like this in all likelihood is probably going forward. Now, that doesn't surprise me. In fact, I would say, even if the SEC had filed late, I'd kind of be surprised if the court didn't allow them to move forward. I just wouldn't be surprised if there was some sort of some level of preferential treatment there. That's all I'm saying. We also had former SEC Attorney Mark Fagel agreeing with what Sherry's interpretation of this was. He wrote the following: "This has nothing to do with the SEC or any supposedly late filing, which wasn't late. This is directed at Larson, who has not yet filed his appearance in this case." And then he says in a separate post, "The evidence shows the SEC Form C was prepared the morning of the 16th when it was due. It wasn't docketed until the following day, but nobody has any evidence that it wasn't actually filed earlier or any explanation for why the SEC would have held it back." Yeah, and so fair enough. His belief is that it was filed that day. We don't technically know that part. I mean, I can come up with theories as to why they didn't. I don't know. The guy filed it, or prepared it rather, didn't technically file it, went out and had a happy hour, got hammered, and then completely forgot. I don't know. I can make up stuff. I don't know. We literally don't know specifically that. I'm just saying what it looks like based on the available information here. But we do know, because there's a timestamp, that he pulled, like the attorney did pull the data on the 16th before the deadline, but just with it not being docketed until the next day, and that's weird because it's supposed to be a real-time system and normally it performs like that. It just leaves some question marks, right? And then we had this. So And look, I'm not in this video, just for the purpose of time, I'm not going to get into so much. I kind of said my piece on this anyway. I'm not going to get into as much about what what is reasonable or what I think about Chris Larson donating $10 million worth of XRP to the Harris campaign, other than to note, look, it's been known for well over a decade that Chris Larson happens to be politically on that side of the aisle. It just is the case. He's clearly not a one-issue voter. It's hard for me to believe that he would think that this is good for crypto, which means, I'm speculating, but I would speculate that means that he cares much about the other stuff and doesn't really much care about the crypto stuff, because clearly this can't be good for anything crypto. I don't know how you could have a reasonable argument. But anyway, so I don't want to get too into the weeds on that. It is just, the news broke the other day. Yes, he did this, and he had already donated $1 million worth of XRP not long before that, so he just upped it. And that's his right to do. He owns an asset. If he wants to sell that, or donate it rather, in this case, he can absolutely do whatever the hell he wants with it. And that's fine. So he's, not everybody's going to agree on everything political. Some people are going to donate on the right, some on the left. Fine, whatever. But the more interesting question for the purposes of a video like this, which is one where I'm talking more about legal happenings, it's what are the implications, if any, as it pertains to the SEC? Because think about this. $10 million in XRP sent from Chris Larson to support Kamala Harris. What about selling that? Do we still have some problems there? So take a look at this. Attorney James Murphy, also known as Meta Lawman, thinks potentially there could be. So he wrote the following: since Chris Larson has donated $10 million in XRP to Kamala Harris, the campaign will have to sell Larson's XRP, presumably on an exchange, to convert it to dollars. Will Harris clear that transaction with Gary Gensler? Will this trade impact the SEC's appeal in the Ripple case? Okay, so you might be thinking, as I did immediately, the same thing that attorney Bill Morgan thought. So he had a response to this, and he's thinking, wait a minute, but, XRP does have legal clarity, so what makes you ask that? Well, check this out. Here's what attorney Bill Morgan had to say. The SEC ultimately did not seek summary judgment against Ripple for gifts, giveaways, and donations. Those XRP, no doubt, were eventually unsold. So, of course, when he says unsold, that just means sold to a secondary party, right? And then he says, why would the SEC care about Larson's donation for Harris? A donation is obviously not an investment contract, and the SEC has accepted that the token itself is not a security. Don't see how on-selling it would be an investment contract. Right, and so that all does make sense, and attorney Murphy, it looks like he does agree, but he actually was trying to make a different point in his initial post. So check this out. So just because XRP itself has legal clarity, and just because the SEC literally is not challenging secondary market transactions other than any that pertain to Ripple specifically, just because that's true, it doesn't mean that there couldn't be a problem with the SEC specifically if this is to be sold. And why? Well, it's because of the convoluted approach that the SEC has been taking to all things crypto. So here's attorney Murphy's response to that. He says, my understanding is it is the position of the SEC that the exchanges, like Coinbase, upon which XRP trades are themselves illegal because they have not registered as securities exchanges. That's why I posed the question about the sale of Larson's donated XRP. I could be wrong, wouldn't be the first time. And so what he's getting at, he's not saying, of course he's not, that XRP itself is a illegal security, or that those transactions can't occur. Like, you and I can buy and sell XRP to our heart's content, right? We're fine doing that. But then the question is, what about Coinbase having not registered with the SEC? I know, it sounds stupid. It is. It definitely is. Because XRP itself is not a security. The SEC's even given this up. Yet, they are still attacking. It's Operation Choke Point 2.0. It's part of it. They are still attacking multiple exchanges for not, because they finally realized, rather than going after each individual ecosystem, coin ecosystem, if you just go after the on-ramps and off-ramps, then you're good. Because otherwise it's like the head of the Hydra, chop one off and that's like another one sprouts up, So that's the point. So it's certainly a reasonable question regardless. Now, attorney Morgan responded to that and said, You could be right, but it shows the absurdity of the SEC's theory about secondary market sales. How does the SEC know whether a sale of XRP on an exchange is of XRP sold by the issuer as an investment contract, on selling the investment contract, or donated to Kamala Harris and not the on sale of an investment contract? Crazy. It kind of stuffs up their theory. Yeah, exactly. And so I enjoy seeing two attorneys within the XRP community highlighting the ridiculousness and absurdity of the SEC's approach to crypto. It does not make sense. Now, of course, this particular transaction here, should it be sold, and presumably it would, I'm just going to go ahead and guess that the SEC will never raise any sort of beef over this specifically. After all, I mean, if you look at who's running the SEC right now, I mean, look at who's in charge right now, the current administration, Wise Gensler there. Just saying. From the top on down, this administration has just been anti-crypto for years on end, and I'm just ready for it to be over. But that's the ridiculousness of all this. So I thought I'd just share it with you because I found it fascinating, and it's just another one of those things that highlights the absurdity of the situation. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.